Good morning, good afternoon for those joining us from the Middle East. My name is Pendananda, Ambassador and Permanent Representative of Namibia to the United Nations, and Vice Chair of the Committee on the Exercise of the Inalienable Rights of the Palestinian People. On behalf of the committee, let me express my appreciation for you being here today. The committee advocates for a just, lasting, and comprehensive settlement of the conflict on the basis of a two-state solution, Palestine and Israel living side by side in peace within the pre-1967 borders, with Jerusalem as the capital of both states. I welcome you to the 427th meeting of the Committee on the Exercise of the Inalienable Rights of the Palestinian People, held on the margins of the 70th session of the Commission on the Status of Women, CSW 70. The theme of this year's Commission on the Status of Women is, and I quote, ensuring strengthening access to justice for all women and girls, including by promoting inclusive and equitable legal systems, eliminating discriminatory laws, policies, and practices, and addressing structural barriers, end of quote. I would like to first invite you to listen to the recording of Her Excellency Mona Al-Khalil, Minister of Women Affairs of the State of Palestine, who will deliver the opening remarks for this meeting. On behalf of the committee, I would like to thank Minister Al-Khalil for making time to be with us today to deliver opening remarks. I would also like to commend her for the work she is doing in the Palestinian government to achieve gender equality, to facilitate women's access to justice, the very topic of this session, and their participation in the national struggle to end the occupation. Minister Al-Khalil, I give you the floor.
Excellencies, ladies and gentlemen, members of the Committee on the Exercise of the Inalienable Rights of the Palestinian People, distinguished guests, I stand before you today to speak about the reality of Palestinian women under the exceptional circumstances our people are experiencing. I'm here to speak to you also about the profound consequences of the ongoing aggression and the efforts undertaken by the Palestinian government in the fields of urgent relief, early recovery, and reconstruction. We do this in accordance with the governmental emergency plan and the international responsibilities that this entails. Ladies and gentlemen, Palestinian women have always been a fundamental pillar for the resilience of the Palestinian society. They are the mothers who protect their families, the teachers who educate generations, the doctors who heal and cure, the workers who contribute to the economy, and the activists who defend rights and dignity. Yet despite all this, women in Palestine pay a dual price during times of crisis and conflict. The ongoing Israeli aggression has intensified the challenges facing Palestinian women. Thousands of women have lost family members. They have been forcibly displaced or have lost their homes and livelihoods. Moreover, settlers have been given free rein as a systemic tool within the policy of forced displacement. This led to increased violence against civilians. This comes hand in hand with the Israeli government's announcement of its decision to annex Palestinian territories in an attempt to seize more Palestinian land by force, contrary to international law. Basic services on which women rely have also been severely affected due to the looting of clearance revenues and tax proceeds. The obstruction of movement between governorates through checkpoints and iron gates and the destruction of infrastructure are also compounding factors. Daily life for Palestinian women has become much more difficult, while their responsibilities within family and society have multiplied. In recognition of the magnitude of these challenges, the Palestinian government has developed a comprehensive emergency plan aimed at responding immediately to humanitarian needs in both the Gaza Strip and the West Bank, including East Jerusalem. This is to strengthen early recovery and pave the way for sustainable reconstruction. The Ministry of Women's Affairs also understands that overcoming the effects of the aggression goes beyond urgent humanitarian response. It requires serious investment in economically empowering women and strengthening their long-term resilience. Women's economic empowerment is one of the key elements of Palestinian society's recovery. It enhances women's ability to support their families, restore their income sources, and participate actively in reconstruction and development. In this context, and through the economic empowerment strategy launched by the Ministry of Women's Affairs for the years 2025-2030, we are working to support women-led economic initiatives. We are also expanding training and employment opportunities and enhancing women's access to resources and financial services and raising women's participation in the labor market from 17% to 22% by 2030, thereby helping them overcome the economic and social impacts of the aggression. Within this framework, the Ministry's strategy is based on three main pillars, namely, protection from violence in both public and private spheres, empowerment in all its political, social, and economic forms, and international pressure and advocacy through the international tools and mechanisms related to human and women's rights. The Ministry simultaneously continues to push for legal reforms that would strengthen women's rights and reinforce the principles of justice and equality within national legislation, in line with the human rights commitments of the State of Palestine. Foremost among these reforms is the reform to the personal status law in order to ensure greater justice and fairness for Palestinian women. Action is also underway through the National Higher Committee for Combating Violence Against Women, chaired by the Ministry of Women's Affairs and composed of government institutions, women's organizations, and human rights institutions, to review and develop the national referral system for abused women. This would strengthen the protection and integrated response mechanisms, along with improving tools for assessing high-risk cases to ensure rapid and effective intervention in cases where women are facing immediate threats. The Ministry of Women's Affairs has also made significant progress in preparing the third-generation National Action Plan for implementing UN Security Council Resolution 1325 on women, peace and security. This will strengthen women's participation in peace-building and decision-making efforts and ensure that their needs and priorities are integrated into national policies and programs, especially in the context of occupation, conflict and crisis. To enhance evidence-based knowledge, the Ministry has also established the National Observatory for Monitoring Violence Against Women in all its forms, including violence by the occupation, social violence, and economic violence. The observatory relies on an integrated information system featuring an interactive map that highlights the patterns and types of violence prominent in each governorate. This enables decision-makers to analyze indicators and design policies, programs, and interventions tailored to the specific challenges of each area and the type of violence prevalent in it, based on accurate and delicate indicators measuring the magnitude and patterns of violence. Ladies and gentlemen, as Palestinian people struggle for their freedom, dignity, and the end of the occupation, they remain committed to their inalienable right to establish an independent Palestinian state on the borders of the 4th of June 1967 with Jerusalem as its capital, in accordance with relevant international legitimacy resolutions concerned with the question of Palestine. From this perspective, national efforts continue in drafting the Palestinian constitution based on a vision that upholds the principles of equality, justice, and citizenship, and guarantees the rights and freedoms of all citizens, men and women alike, without discrimination. This reflects the aspirations of the Palestinian people to build a modern democratic state grounded in the rule of law and respect for human rights. Ladies and gentlemen, the scale of destruction and the scope of the challenges far exceed our national capacities alone. Therefore, international support will be a decisive factor for the success of efforts for relief, recovery, and reconstruction. The international community, under international humanitarian law and relevant UN resolutions, bears a clear responsibility to protect civilians and ensure unimpeded humanitarian access and support reconstruction and development efforts. The empowerment and protection of Palestinian women must also be an integral part of any international response to the crisis. Investing in women is not only a humanitarian necessity, but also a fundamental condition for achieving sustainable recovery and building peace. Ladies and gentlemen, our shared duty today is to ensure that Palestinian women are not left alone facing these challenges. Supporting and empowering Palestinian women must be an integral part of all national and international efforts to provide relief to our people and promote our people's recovery and rebuild what has been destroyed by the aggression. In conclusion, we reaffirm that realizing the inalienable rights of Palestinian people, foremost among which is the right to freedom, dignity, and self-determination, is the true path to guaranteeing security, stability, and prosperity for all. In this context, this goal will not be achieved without an end to the occupation, as the occupation remains the primary obstacle to women's advancement in the state of Palestine. Palestinian women will continue to be an essential partner in building the future our people deserve. Thank you.
As stated by the UN Women Executive Director, Sima Bohaus, where access to justice is a reality, women and girls thrive. Solutions being addressed by member states and the participants of this year's CSW include, amongst others, the prioritization of gender-responsive, survivor-centered, and trauma-informed justice services, and the guarantee of accessible legal aid and justice mechanisms that comply with international human rights standards. The Commission on the Status of Women is a unique space for us as member states and the committee as a whole to engage with civil society and women's rights organizations, including from the occupied Palestinian territory, and hear personal testimonies of how the Israeli occupation has been impacting Palestinian women in a disproportionate manner. The committee seizes the opportunity of the Commission on the Status of Women to invite expert speakers from the occupied Palestinian territory and Israel to share their expertise at the Commission's annual session in New York as part of its efforts to mobilize the international community on the question of Palestine and to cooperate with civil society organizations from across the world. This year, the committee is organizing this event under the theme, and I quote, "Discriminatory Laws and Policies Against Palestinian Women and Girls Under Israeli Occupation. Justice Demands Accountability," end of quote. For over half a century, Israel's policy on land confiscation, illegal settlement, and dispossession have inflicted immense suffering, depriving the Palestinian women of their basic rights. The structure of the occupation and its effects are especially damaging to women who do not have equal access to justice or equally affected social platforms to address this imbalance. Violations against Palestinian women by the occupying power include property destruction and demolition, forced evictions and population transfer, separation of families, mistreatment of female prisoners, targeting human rights defenders, restrictions on freedom of movement, and expression and checkpoint violence. Such violations, however, perpetuated directly against women and their family members, have a profound and damaging effect on women. As long as Palestinian women live according to the whims of Israeli occupation and creeping annexation of Palestinian land, their human rights will not be realized. Access to justice is both a basic human right and a means of implementation of other human rights. Justice is rooted in all national cultures and traditions, and traditional judicial mechanisms. Translated to the case of Palestine, the access to justice for Palestinian women is directly linked to their liberation struggle, to realizing their right to self-determination, ending occupation, and establishing an independent Palestinian state. Most importantly, ending the occupation goes hand in hand with ensuring the accountability of Israel for its crimes and violations under international human rights and humanitarian law. The committee consistently calls for the latter and has intensified its calls amidst the military aggression on Gaza and creeping annexation of the West Bank for the end of the unlawful Israeli occupation and subsequently for the implementation of 2024 International Court of Justice Advisory Opinion. Ladies and gentlemen, Your Excellencies, in light of the grave security and political situation in the region and the prospects of peace and state solution becoming more challenging every day, we will focus in this gathering on the binding obligations of the international community in ending the unlawful occupation and realizing the rights of the Palestinian women for justice, particularly in the upcoming phases of the peace process. The briefings will offer member states first-hand perspectives, legal analysis, and updates from the ground. The recent political developments in the Middle East have not only been impacting the situation of the Palestinian people on the ground, but have also made their participation in international platforms like this one more difficult. Adding to the challenge of their in-person participation are the restrictions on the granting of US visa to participants with Palestinian passports, combined with the closure or unpredictability of airspace in Israel and Jordan in the recent weeks of the Iran war. Today's panelists have no option but to intervene via video teleconference instead of in person, as originally planned. In this regard, the committee would like to raise attention to the increasing restrictions of international human rights defenders and women's civil society organizations working on the question of Palestine to important gatherings such as the Commission on the Status of Women. The Commission on the Status of Women should indeed be the platform to amplify the voices of the marginalized and to ensure the representation of Palestinian women. Their exclusion resulting from political decisions, although beyond the control of the committee, should be denounced. I will now move to the panelists for their remarks on the different topics, ranging from access to justice in the context of the ongoing war on Gaza and destruction of existing judicial mechanisms, to the deprivation of rights under the Israeli occupation system, and discussions on potential reparation and restitution of Palestinian women. Our first speaker, Ms. Amal Syam, is intervening online from Gaza, Gaza City. Ms. Syam will intervene on the topic gendered impact of the Israeli war on Gaza, ending impunity for violations of Palestinian women's rights. She is a Palestinian women's rights advocate and the General Director of the Women's Affairs Center in Gaza. She is involved in advancing gender equality, women's empowerment, and inclusive participation in policy processes in Palestine. She has led initiatives aimed at addressing harmful gender norms and socio-cultural practices, including efforts to combat gender-based violence. The work of human rights defenders like Amal Syam is described as vital by the UN Special Rapporteur on Human Rights Defenders, Mary Lowler. Carrying out such work while trying to survive a war, and siege carries unique challenges. Her work has also been referenced in academic and policy literature addressing women's leadership and activism in the Middle East. Since the ceasefire of 10th October 2025, Israeli airstrikes and shelling have continued to cause death and destruction among Palestinian residents. Medical evacuations are still on hold, and only a limited number of commercial supplies have been permitted to enter. The committee continues to call for an end to Israel's destruction of the living conditions in Gaza and to stop its endless war on humanity. Ms. Syam, you have the floor.
I am speaking with you today from the Gaza Strip, a Gaza Strip that is now without justice.
وقبل أن نتحدث عن وصول النساء إلى العدالة بالتأكيد دعونا نتحدث عن
And before we can speak of women's access to justice, we must speak of what has befallen the Gaza Strip since October 7th. And allow me to say that Israel continues its aggression against the Gaza Strip.
وإسرائيل مستمرة في سياسات القتل والتهجير والتدمير والتجويع.
And continues its policies of destruction and starvation and displacement. Homes and buildings and infrastructure are still being targeted, and civilians are still being targeted in tents and everywhere. As Her Excellency the Minister has said, women always pay the highest price. And Palestinian women have truly paid a steep price during this war. All international laws and human rights conventions have failed to protect Palestinian women. We have lost 33,000 women to this genocidal war, 9,000 of whom were mothers. We have lost more than 2,700 families that have been completely eradicated, and over 6,000 families have left behind only a single male or female survivor. Women have represented over 40% of injured civilians in this aggression against the Gaza Strip and the genocidal war. And more than 22,000 women have now become widows facing this world alone. Israel has destroyed everything. Israel has completely destroyed Gaza. It has destroyed over 90% of the Gaza Strip. It has forced over 2 million Palestinians to become displaced as they are suffering strikes and facing death. And in the face of this destruction, we have lost everything. We've lost our homes. We have lost our property. We have even lost our clothes and our identifying documents. And now, after the so-called ceasefire, 1.5 Palestinians remain in camps and shelters that are not safe and do not have the most basic requirements for life. And Palestinian women bear the biggest burden in such circumstances due to the lack of privacy and the overcrowding of the shelters. The war has overburdened women and has forced women to stand in very long queues in order to access water and food. Palestinian women have faced many difficulties in fulfilling basic needs. The healthcare system has also completely collapsed, and over 49% of healthcare facilities have been destroyed, which has reflected negatively on different categories of women, especially injured women and cancer patients and women with disabilities and women living with chronic diseases. The women of Gaza have also experienced traumatizing situations. They have experienced multiple losses and have experienced repeated displacement. And now they suffer anxiety and depression and despair and frustration and fear. Now back to the issue of access to justice and the legal situation in Palestine, specifically in the Gaza Strip. Palestinian women, as a result of the continued occupation and as a result of the repeated and recurring wars on the Gaza Strip and the consecutive aggressions and the genocidal war, face multiple challenges in access to justice in the Gaza Strip and in Palestine. Justice requires a fair legislative environment and a supportive societal culture and an economic situation conducive to women's demanding their rights without fear and without hunger and without displacement and homelessness. These requirements unfortunately, are not available in Palestine, especially in the Gaza Strip. In the Gaza Strip, we have to resort to an obsolete legal system built on old legislations that have been passed down from a bygone legislative era. We are also facing a problem due to the lack of standardization of the laws between the West Bank and the Gaza Strip. For example, we also have to resort to the family law, which is one of the most important laws, and which is also referred to as the personal status law, which manages family affairs and organizes family affairs, and is considered one of the key laws that affect the status of women within the family directly and significantly, and this law determines women's legal status. In the Gaza Strip, the family law that was issued by the Egyptian administration in 1954 is still in effect now that we are in 2026. In the West Bank, the Jordanian law 61 of 1976 is still in effect. And the Penal Code of 1936 is also still in effect. In brief, we are resorting to a very old and obsolete legal system that cannot protect the rights of women. Let us ask, in the face of the consequences of the war on Gaza, have we as women stood watching idly by? Have we as organizations stood idly by watching women suffer difficulties in accessing to justice? The answer, of course, is no. Our organizations are still working on the front lines. We have issued documentation for women, such as birth certificates and certificates for custody over children and certificates proving different kinds of statuses, and we continued our work through the displacement and through the destruction of the judiciary institutions. Courts were completely destroyed. The entire legal system was destroyed in the genocidal war. We also provide numerous legal consultations and increase legal awareness for women within these shelters, whether in person or through mobile phones. We have also activated free phone lines for women to facilitate their access to services. And we have also provided a multi-sectoral package of services because legal services cannot be provided in isolation from other kinds of services, so that we can truly say that women have sufficiently benefited from these services. And let me tell you now that the judicial vacuum created by the occupation and created by the destruction of the instruments of the law has caused major transformations in how issues are addressed with regards to Palestinian women. The official judicial pathway has collapsed. Therefore, alternative methods have emerged to address women-related issues. This shift towards alternative methods, specifically mediation, was not organized and was not supported by a legal framework, but rather was a popular reaction to the collapse of formal justice. It was a reaction to the lack of alternatives provided by the formal regime, as the formal regime did not provide alternatives to us as women during the war. Therefore, individuals and institutions, including feminist institutions, took the initiative of switching to alternative methods for resolving women's issues to ensure their access to justice. Mediation was used widely in displacement camps and shelters and schools, even underneath the rubble of destroyed buildings. Through mediation and alternative solutions, we were able to increase civic peace within the Palestinian society in the Gaza Strip. Nevertheless, these solutions still face major challenges, especially when we speak of legal guarantees. Solutions are also coming from individuals whose proposed solutions will depend and vary based on their awareness of women's issues and their own backgrounds. And before I conclude my statement, I affirm that we must continue to document Israeli violations, as there is great legal and humanitarian and historical importance in documentation, because this documentation makes our testimony as victims usable evidence in holding Israel accountable and in persecuting war criminals and holding them accountable and protecting the rights of victims and supporting the Palestinian narrative. And as Her Excellency the Minister has mentioned, with your support, we must push for the rapid launch of revitalization and reconstruction and the allowing of unimpeded humanitarian assistance in all its forms, to allow for the rebuilding of the legal system and the judiciary. And with your support, we need to rebuild in Palestine. We need your support for the efforts of the Palestinian people to liberate themselves from occupation. Thank you.
Ms. Syam, we thank you for sharing insights on the situation of Palestinian women and commend your resilience in supporting their legal rights amidst these very difficult circumstances you are cooperating under. We understand that you have to leave soon to break your fast. We thank you for your time. The next two speakers will be presenting on access to justice and accountability, discussions on reparations and restitutions for the displaced women in the West Bank. I would like to invite the second speaker, Ms. Sawsan Zaher, to take the floor. Ms. Zaher will be addressing the role of the Israeli Supreme Court in blocking reparations and providing impunity for Israel's war crimes. Ms. Zaher is a human rights lawyer based in Haifa, Israel, and a constitutional litigator on behalf of Palestinians in Israeli courts. She has been a legal advisor for several Palestinian human rights and feminist organizations, both on matters of Israeli and international law. She recently represented the Palestinian Authority in a constitutional petition brought before the Israeli Supreme Court, as well as the National Committee for the Arab Local Councils in Israel. Up until August 2021, she served as a Deputy General Director and Senior Lawyer at Adala Legal Center, where she worked for 16 years. Madam Zaher, you have the floor.
Thank you for the invitation for this important convening and important discussion. I would like to address to continue what Ms. Amal Syam was saying about the importance of access to courts, access to justice as part of bringing Israel accountable to all the crimes that it is committing against the Palestinian people, mainly in Gaza, mainly during the genocide. And in order to do that, I will focus on the Israeli legal system, because I know that my colleague Ms. Lina will address other international levels, but also would like, through addressing the Israeli legal system, to show basically how the Israeli legal system was designed intentionally already from decades ago in order to achieve and in order basically to bring impunity to the genocide and to all the crimes that have been committed by the Israeli soldiers on individual basis and by the army on a systematic and policy basis. Of course, we all know that this is not the first aggression of Israel on Gaza. After the disengagement, Israeli disengagement plan in 2005, we had the first Israeli military operation on Gaza in what is known Kastled in 2008-2009. And then we had the 2012, and then the Operation Protective Edge, based on the Israeli nickname, in 2014. Then during the big March of Return in 2021, and later on during the genocide beginning of October 2023, which is basically not stopping until now, despite the superficial declaration on ceasefire in last October 2025. Now, when we are checking and observing basically the legal military system, which has the responsibility to investigate grave violations of human rights in order to bring the perpetrators accountable on all level of the military chain, whether it should be the commanders that gave the commands or the soldiers on an individual level that committed the crimes in the field, we can see that the Israeli legal system basically has never been neutral, has never been independent, has never conducted prompt and professional investigations, and all the investigations or even the internal checks that have been operated in the military Israeli legal system have never, since the disengagement and since Kastled until today, have never led to any indictment on grave violation and grave crimes against Palestinians. The military system is basically comprised of three levels of investigation, or three levels that start with an internal, what is called operational debriefing, which is conducted in the same unit that the soldier or the perpetrator is basically affiliated with. It has nothing to do with any criminal investigation. It has nothing to do with basically bringing any recommendations to the military advocate general, but its main idea or its main purpose is basically to learn lessons in order to improve the military violations against the Palestinian people, and not to put perpetrators accountable under any criminal investigation. So this is not, even if the vast majority of the incidents go through this operational internal debriefing, most of them basically are closed, and the purpose, as I said, is basically internal lessons, learning lessons inside the Israeli army. The second level, which is also internal in the army itself, but not in the same internal unit that the soldier is related to, is called the fact-finding assessment mission, which basically tries to check and investigate the matters and the incidents in order to give a recommendation to the military attorney general whether to open a criminal investigation or not. Now, hundreds of cases in the past 20 years, since First-Land until today, including the genocide, hundreds of cases and complaints have reached the fact-finding assessment. However, when we see that the number of recommendations and decisions of this fact-finding assessment inside the military, which led to a recommendation for the military attorney general to open a criminal investigation, we see that if we take only during the genocide alone, which is 2.5 years ago, when we know all the numbers of the high casualties that were also debriefed by Ms. Amal, we are talking today about a maximum 80 cases that are being criminally investigated by the military attorney general, while hundreds of more than 700 complaints have reached the fact-finding assessment, while only 80 or 85, like the number ranges basically, and no one yet knows the exact number, but it is average of 80 criminal cases. However, when we dig more in depth into the results of the criminal investigation that has been opened by the attorney general of the military, we see that so far there has been only one indicted soldier, which has been indicted for theft and looting, and based on the facts that I understood of that case, it was a looting of 5,000 shekel from a home in Gaza that the soldier basically occupied after the evacuation of the Gazan family. And when he tried to put the cash in the Israeli bank account, the bank basically exposed that most of the cash was not real cash, which led to the opening of the investigation. But this means basically that the conclusions that we can take only from the numbers is that even if there are two main levels of investigation, if we put aside the operational debriefing inside the unit itself, we can see that the system is basically built on a system that will defend any operation of the army, especially when we are talking about the genocide. And let us not forget that the military attorney general is basically the same person that gives the legal advice to the army to conduct the operation. So he or she, lately it has been she until she was basically fired after the Stateman leaking of the video of the Gazan detainee who was allegedly raped in Sdeiman. So far, she was basically giving the legal advice and also supervising the investigations. So if someone has a dual hat, of course, the immediate conclusion is basically conflict of interest, which is by no surprise leading to as well the total impunity that the army is giving to itself. Now, the other question is, okay, so if the army is providing full impunity to itself, and we also need to take into consideration that the context and the kind of violation. We're not just talking about the killing and the destruction and the bombing. We are talking about several other grave violations that also affect women, and that they have a gender component. For example, looting, and we can see that, of course, we know that from soldiers, Israeli soldiers who were filming from inside Gaza, from inside the home, taking photos with women, night lingerie, speaking about how they rape not only women but also children and kids, showing how basically they are entertained by the fact that they are destructing and killing and basically willfully translating the genocidal intent, knowing that they are backed up also from the political system. So it is not only a military criminal legal system that is providing full impunity, but also a political system, especially that it starts with statements from the President of Israel to the Prime Minister to several members of Knesset that dehumanize Palestinians in Gaza and, of course, in the West Bank, and all Palestinians as such. And when dehumanization is the basis of all the military operation since day one of this genocide, then we know that soldiers will not hesitate, basically not only doing all the grave crimes that we hear and we read upon, but also all different of other crimes that also have an immediate effect to women. Now, the question now is what happens with the Supreme Court? Okay, so the Supreme Court is the legal has the only exclusive, basically, authority to provide judicial review over all authorities in Israel, including the army. But since the beginning of the occupation in 1967 until now with the genocide, the Israeli High Court never agreed to intervene in the Attorney General decision not to open or not to indict or against the closure of any investigation done by the army. So, and the reasoning, the legal reasoning that they provide is that they will not interfere in the professional and security reasoning of the military investigation, where they have all the means to conduct the investigations. But when we look at it from a different side, the opposite of what the Supreme Court basically rules is that the Israeli army has been prohibiting foreign journalists from reporting from inside Gaza. The Israeli army has been also occupying on the ground and therefore basically controlling every kind of evidence on the ground in order to be able to take it for the investigation itself. Probably a lot of the victims have been dead. Whoever survived, especially among women, is not able to access neither and will not, of course, because we're talking about a trust issue, that even if they can, they will not. But even if they want to, they cannot, because based on other Supreme Court decisions, all Gaza have since 2007 been declared as an enemy entity, which basically led to the prohibition of the entry of all Gazans as such, in order to enter Israel and submit lawsuits against the Israeli army. And this brings me to another aspect of the full impunity, because not only there will not be criminal investigation and no indictments, in contrast to international law, which will not bring effective remedy as well and justice to the victims and to the survivors, but also the other aspect of effective remedy is the ability for the survivor and the victim to demand compensation on what the army has basically the damages that the army had caused. And based on an Israeli law from 2012, all Gazans were prohibited from submitting civil lawsuits in Israeli courts against the Israeli army, only because Gaza has been declared as an enemy state. Now, when we take these two systems, the demand for civil compensation and the full impunity, and we also of course, it's not only, vis-a-vis in parallel to the Israeli decisions or the conclusions, which are not being trusted also on international level, not only on a local Palestinian level, because every military operation, the UN establishes a commission of inquiry, whether it started from the Goldstone report, the commission of inquiry on Castled, and so on. Every time the UN commission of inquiry basically concludes that the Israeli legal system, the military one and the civil Supreme Court one, do not meet with international standards in terms of conducting investigations and as well providing compensation. So when we are, and by the way, just to give another example, that in the Israeli public, justice to Gazans is not even a concept that is not only known or acknowledged, but it is condemned, because when we're talking about dehumanizing Palestinians in Gaza while during the genocide, and of course in the West Bank, no one is looking at Palestinians as humans, but as animals, as people who don't deserve and who have no right basically to access not anything in Israel, but also of course the legal system. And this can be reflected in one example, which basically relates to the video that was leaked by the former military attorney general Yifat Tomer Yerushalmi about the raping video against a Gaza detainee in Sdei Timan. Sdei Timan is basically a torture camp that I am sure most of you have heard of. And because of the leak, she was, of course, fired. There was an indictment that she's now being under investigation by the police. But there was an indictment against the persons that were involved in raping and in basically against the violation against the Palestinian in Sdei Timan. And only last week, the court basically decided to cancel the indictment. And when we see the video of these indicted soldiers getting inside the court, they were blessed with clapping hands, with greetings, with blessing from the public as they were heroes. So the mentality and the state of mind among the Israeli public is in no way aligned with even the conversation that we are having, not to say international law or international humanitarian law or even standards of the UN, and of course not standards of the respected commission that now we are talking. Now, I think that for us, this is not new. For people who really know the Israeli legal system, this is not new. The Israeli legal system has never been an answer or an address for effective remedy for Palestinians. And this is why the important question is, what about the international tribunals? What about the arrest warrants against Netanyahu and Gallant? What about issuing other arrest warrants against other personnel who are not only not doing anything to stop the genocide, but are encouraging the genocide, not only from political reasons, but also from religious, Jewish and Zionist reason and motives. So I will stop here and give Ms. Lina to continue. Thank you very much.
I will now turn to the third expert, Ms. Lina Fattom, who is connecting from Ramallah. She will also be presenting on access to justice and accountability, discussions on reparations and restitutions for the displaced women in the West Bank, and will provide an international law perspective. She is a Palestinian human rights lawyer who trained in the US and specializes in public-private international law and corporate litigation, as well as cross-border arbitration and negotiations. Her previous experience includes serving as director of the innovative private sector development project, legal advisor to the Palestinian negotiating team, human rights attorney with Amnesty International, advisor with Al-Haq to the Norwegian Refugee Council and Oxfam, and manager of the Diakonia International Humanitarian Law Center in Jerusalem. Ms. Fattom, you have the floor.
I'm going to go quickly through just the idea of reparations under international law as a mechanism for justice for Palestinians, and then focusing a little bit more on Palestinian women. As we are all, and as you know, reparations are a recognized mechanism or consequence of international wrongful acts to help restore the situation to how it would have been without having had the wrongful act take place. And it's a form that is usually used against states. It applies normally in the context of international armed conflict as well as non-international armed conflict, and is now also recognized as a form of rectifying harm for violations of human rights, international human rights, and international criminal acts. This, traditionally and historically, it's been used as a reciprocity tool since the World War I, and through today, it is a recognition of an international legal order that the UN is part of, and a mechanism that is reinforces the rule of law within and between states. It is also now generally recognized in a general consensus that the right of reparations is a right, not just helpful, but rather it's a right for international wrongful acts. And as you see on my screen, the reparations can be between two states. It can be between states and peoples, and it can be between states and individuals who've had harm come against them. And they treat both individual violations of rights, but also collective violations or structural violations. Generally, reparations often take place in situations at the end of conflicts, or in peace treaties, as part of peace treaties, but also as transitional justice mechanisms and as accountability mechanisms, including through international and state courts. The legal basis of reparations comes from customary law, and it includes it for use cogans or peremptory norms that are non-derogable. It is also binding on all states for those use cogans. And that's important for something that I'll mention later on, as you'll see under the ILC draft articles on state responsibility, which also includes, obviously, jurisprudence from the ICJ cases and other international tribunals that developed the law. It stems also the legal bases for reparations from the UN Charter, from Geneva Conventions, from UN Basic Principles, and from UN resolutions. It is also embedded within the Rome Statute of the ICC. It is in IHL, International Humanitarian Law, including through the Geneva Conventions and Protocols, as well as customary law. It is within the International Human Rights Conventions, and I mention here the ICCPR, the International Covenant on Civil and Political Rights, as well as the International Covenant on Economic, Social, and Cultural Rights, and of course CEDAW, which the Covenant on the Elimination of Discrimination Against Women, which requires states to ensure that remedies are also gender-based for gender-based harms. Finally, of course, local state laws can incorporate these international legal frameworks, or it can codify them directly, whether through direct local law or by codifying the international mechanisms that have to codify some of these reparations schemes. So what kind of reparations are we talking about? Of course, the primary form of reparations for international harm has always been restitution. So it's trying to restore victims to their original situation. And that may include the return of property, the return of land, the return of people to their land. And it is required unless it is materially impossible or involves a burden out of proportion to the benefit. And we can talk a little bit about what that looks like in the Palestinian context going forward. In addition to restitution, and sometimes in the case where restitution is not available, compensation, monetary payment for economically accessible damage is allowable. Rehabilitation is also an important part of reparations to be more comprehensive. That includes medical, psychological, social, and legal support to communities or individuals that have been harmed. And then satisfaction. And we see satisfaction becoming more and more prominent. It's the acknowledgement of harm by the state or states that have carried out this harm. This may include apologies, it may include memorials, it may include truth-telling, depending on the type of approach that's being taken for the harm that we're talking about. And of course, guarantees of non-repetition of that harm. So ensuring that structural reforms to prevent future violations. And this is particularly true for use cogans. So just a quick overview of things that everybody in this room already knows. In the West Bank, there are a total of 3.5 million people, Palestinians, who live in 5,860 square kilometers. Approximately of this population, approximately 900,000 to 1 million are Palestine refugees from the 1948 areas. There are also those who are from the West Bank and are no longer able to return to the West Bank based on 1967 violations. As everyone knows, the prolonged and now illegal occupation has taken over 59 years, has caused irreparable harm, including through different kinds of crimes against humanity that I mention here, which persecution, apartheid, and genocide, all three of which are peremptory violations of peremptory norms, which are important for third state responsibility. Of course, there are other kinds of war crimes, including the forcible transfer of populations, Palestinians, from their land, the continuation of the building of settlements, which violate a number of different pieces of international humanitarian law, the extensive appropriation and destruction of property, which violates both international humanitarian law and international human rights law, and of course, the daily violations of extreme bodily harm and denial of fundamental rights of Palestinians, many of which amount to war crimes. So in the state of Palestine or in Palestinian areas, the kinds of violations that we have to deal with that can give rise to reparations include structural or collective crimes, such as the violation to the right to self-determination. This includes colonial domination, foreign prolonged occupation, and denial of sovereignty. And based on, of course, the most recent ICJ advisory opinion of 2024, this prolonged occupation that is now illegal must end. And part of that reason is that it is because it violates the Palestinian right to self-determination, in addition to many other violations and war crimes. So what does that look like? It is a collective remedy, including ending the occupation, restoring sovereignty to the rightful owners, the Palestinian people, and restitution of land and resources. This can be both collective and individual. Additionally, violations against Palestinian refugees and against the right of return. So this is rooted in UN General Assembly Resolution 194, but has become part of customary international law based on other conflicts worldwide. The violation is the forced expulsion of Palestinians, the denial of their right to return to their homes or to their properties, the destruction of those properties, and of course, all kinds of other violations that result from these forced expulsions. And this relates specifically to those refugees from 1948, but also from those from 1967 who are no longer able to return to their land in the West Bank or Gaza. The type of reparation that we would likely see under this is restitution, the return of these people to their land and properties, if possible, compensation, in addition to compensation for losses, guarantees of non-repetition, and acknowledgement and apology for the harm caused to begin with. Both of these, I would say, are structural harms that would require quite a bit of political will and movement by the states in order to ensure that this takes place. Of course, violations of international humanitarian law, many of which you've heard about today, whether it's in Gaza or in the West Bank, and violation of being able to access redress through Israeli courts is also part of this. Restitution here, again, becomes important. Crimes under international criminal law. Here, I think that what's interesting for us to also remember is that while reparations can happen during a peace treaty, they can also happen through justice mechanisms such as the courts. And here, there's a role for third states to allow for Palestinians to access those courts, whether they are international or state-based courts, to address some of these very heightened violations of international law. I'm going to stop here in terms of the application, because there is so much that we can say about this, and people have written dissertations. But I think everyone's aware of the types of violations that we're talking about, and I think it's really important to acknowledge that they're both collective violations and collective reparations that are needed, as well as individual. In terms of how this impacts women and girls, these violations, as we all know, violations of international law disproportionately, no matter where or how, disproportionately affect women and girls, both directly and indirectly. And this is something that has been recognized over time through many different conflicts, but particularly in the Palestinian context as well. Often in situations where displacement and loss of property take place, women bear the burden of maintaining families after this. They lose their homes and livelihoods, and this generally means that they also may lose their economic power and sovereignty. And this, in the case, for example, of Palestine, we see this in very, very drastically in Bedouin communities who are also refugee communities in Area C of the West Bank. Those Bedouin communities that have been forcibly removed from their traditional lands have seen a drastic loss of economic power in general, and then a very severe effect on women and girls who used to have their power within the community be based on their activity with the livestock that they took care of. In these new places that they were forced to move to, that were quite tight, without any access to land and to the ability for their traditional way of life, they lost their role within the community and within the family. And that meant that they were more economically disadvantaged, but also had less of a say in the future of their communities. Additionally, this impacts access to health and education, as we well know, and causes significant psychological trauma. I know that my colleague from Gaza, Amal, has already spoken quite a bit about this, but this is not limited to one area of Palestine. Despite the severe situation of the genocide in Gaza, this continues also in the West Bank in a way that is quite traumatic and continues to deteriorate the situation for the Palestinian civilians who live under this continued violations. The structural discrimination that takes place, of course, means that it exacerbates patriarchal structures, as you heard from also my colleague from Gaza. Whatever reparations that take place must include guarantees of non-repetition and strengthen the rights and representation of Palestinian women, including through the political framework. And here I would just mention, obviously, the UN Security Council Resolution 1325, which calls for women's participation in peace processes. And it recognizes there that there is a specific role for women in ensuring that post-conflict reparations address women's violations specifically as well. And of course, gender-based violence is something that we see heightened in any situation of violence, such as the prolonged and illegal occupation in Palestine, where the brunt of the political violence is then carried through into home-based violence, whether it is directly from the occupation, from soldiers increasing the sexual violence, harassment, and exploitation of women, whether it's during displacement or in detention of Palestinian women in Israeli prisons, or in communities where they are harassed, particularly those on the fringe of more built-up areas, as well as, of course, within the home, where the increased repression and oppression of men also means that there's a heightened level of home-based violence as well against girls and women. This kind of violence must be addressed in any reparations, and it must be addressed specifically for women. In order to restore women to their rightful place in their communities, in traditional Palestinian communities, or in the more modern approach of women's participation, there must be an inclusive and participatory design of reparations for that. So what does this look like? I think I spoke a little bit about this, including the restitution for ensuring women are able to get back their land rights, their property rights, which are often overlooked in favor of men, financial redress for widows, for single mothers, for survivors of gender-based violence, rehabilitation, that means increasing the access to healthcare, including through psychosocial support and education programs specifically for girls, who are often most disadvantaged whenever the education system comes under attack, as we see now in Gaza, for example. We also understand now more than ever that satisfaction, official acknowledgement of gender-based and gender-specific harms, and memorializing of women's suffering is an essential part of ensuring that reparations or restitution can take place. At the end of the day, what does this mean for third states? Now, certain rights, like non-acquisition of territory by force, or self-determination, or prohibition on genocide, or prohibition on apartheid, all of those laws or international wrongs are accepted as erga omnes, jus cogens, and that means that they have party or third state obligations to all to ensure that there is non-recognition of these violations, that there is non-assistance of these violations, and in fact, there is an argument now more than ever that all states must cooperate to end the serious breaches of these peremptory norms or use cogons. That means that all states should take steps to bring the violations to an end in whatever way they can, including by providing sanctions, including by providing diplomatic pressure or support accountability mechanisms, whether they're international, like the case of the ICC court system, or the ICJ cases that continues to go forward on the genocide. Also, ensuring that within their own state boundaries, it allows for, whether it's universal jurisdiction or extraterritorial jurisdiction, to allow that some of these violations may be brought forth in their systems to ensure accountability of those who carry out these violations, and including for economic purposes. What does this mean in the application of the Palestinian situation? It means that states, for example, regarding Gaza, should not assist in maintaining the blockade and should not be allowing to continue arms trade, knowing that the arms that are being sent or being traded would allow for continuing violations against Palestinians, whether in Gaza or in the West Bank. This also means that wherever there is a case where economic ties to settlements or that allows for a continuing annexation of territory to go forward, that might mean that those states that are acting in these ways, that are providing assistance or recognizing the unlawful acts in ways by either by actions or by word, might mean that they might also have direct complicity in those actions. And that might mean that actions can be taken against them, including for reparations for Palestinians. So I know that's a lot to say. I know that there is a very difficult situation politically of ensuring that the enforcement of these rights, including the right to reparation, goes forward, particularly in the Palestinian case, even though we know that this has happened historically in many different and very difficult situations, whether that was in Germany following World War II, or whether it was in Bosnia and Herzegovina following the ethnic cleansing that took place there, South Africa with apartheid, Japan and Korea following kind of the wartime sexual slavery, in the case of Namibia following the occupation in the end, and the reparations that were supposed to come from Germany. All of those cases, they teach us certain lessons about how reparations can take place in the Palestinian context, that we need to address the individual harm, the losses and the trauma, both, that we need to uphold collective rights, the self-determination and sovereignty, that we need to ensure third state responsibility in enforcement of these rights, including through ensuring that they act within their accountability and ensuring that they take the actions necessary to ensure accountability of the Israeli offenders. These rights must be gender sensitive. They must recognize the disproportionate impact on women and girls, and they should be rooted in Use Kogan's norms. You cannot have reparations for apartheid until the system is dismantled. And that is part of what we're here to talk about. And I think the structural reparations are just as important as the individual, although both are equally important in addressing the harm that takes place, whether it's in the West Bank, in Gaza, or to Palestinians worldwide. Thank you for your attentiveness.
Lastly, I would like to give the floor to Dr. Carol Daniel-Kasbari, who traveled from Atlanta to be here with us today. She oversees global conflict resolution initiatives at the Carter Center, where she designs and leads strategic programs in mediation and political dialogue. She will present on the incorporation of gender into the implementation of the General Assembly Resolution ES 2020-10/24 and the prospects of current political initiatives and reconstruction of Gaza. She will be addressing, among other things, the concrete steps member states should take to ensure that Palestinian women's rights are protected under the current fragile ceasefire and discussions on the reconstruction of Gaza. Dr. Daniel-Kasbari has more than 20 years' experience specializing in complex political environments in the Middle East, North Africa, and Europe. Her work examines how governance systems and conflict dynamics shape women's political participation, access to justice, and long-term social stability. She has directed initiatives in Palestine, Israel, Jordan, Iraq, Sudan, Syria, Turkey, Cyprus, and Bosnia, facilitating mediation processes and contributing to sustained second-track diplomatic efforts. Across this context, she integrates gender analysis into political frameworks, ensuring that women's voices and civil society actors are structurally included in decision-making processes. Dr. Daniel-Kasbari, you have the floor.
Thank you very much. Chair, Excellencies, and colleagues. Thank you so much for making space for the civil society in this room. In moments of political stalemate, it is often civil society, and especially women, who hold communities together. Making room for those voices here matters, especially at this time. General Assembly Resolution ES 1024 calls for immediate measures on protection, humanitarian access, and the condition for sustainable peace. Bringing a gender lens to its implementation means more than just including women in the room. It means ensuring their safety, access, and participation are built into the political arrangements that follow. At its core, implementation is about access. Access to movement, protection, documentation, governance, economic recovery, and a real voice in the decisions shaping Gaza's future. Under occupation, as you all know, discrimination is often structural, like my colleague Lina Fattom just mentioned. It's really structural violence. It does not appear as a law that says women cannot do this or women cannot do that. More often, it appears through blocked access, a permit that never comes, a crossing that never opens, a document, a civil document that cannot be replaced, a complaint that cannot be filed safely. So today, I want to focus not only on discriminatory laws in the narrow sense, but on the wider system of restrictions, movement controls, blockades, registry systems, detention centers and practices, and administrative barriers that shapes women's lives in ways that are both political and deeply, deeply personal. Let me highlight three realities that makes this moment so urgent. First, as my colleagues already mentioned before me, about the scale of harm and the lived experience of this crisis. Since October 2023, but let's not forget also decades before then, the scale of loss has been staggering. UN Women has estimated, like also the minister has mentioned, more than 33,000 women and girls have been killed in Gaza since the war began. At times, we were counting of averaging of 1 woman and 1 girl every hour. OCHA continued to document repeated displacement, movement restrictions, and the loss of documentation and family records as central features of civilian vulnerability. These are not side effects of the war. These are part of a wider system that shapes women's access to safety, healthcare, housing, and legal identity. In February 2024, the UN human rights experts raised alarm over credible allegations of violations against Palestinian women and girls in detention. and called for independent monitoring. One released detainee described feeling as though she had disappeared into a system where no one could see or hear us. And another woman, human rights defender, says it's not only the bombs that make us unsafe, it is the feeling that the system itself does not see us. That invisibility is in itself a form of discrimination. Displacement across Gaza has forced families to move again and again and again, often losing documentation, property records, and community anchors each time. Losing papers is not symbolic. Without documentation, people cannot prove land ownership, access services, or unify family members. These are not isolated hardships. They reflect systems of control sustained over a long time. Second reality is we need to look honestly at what the current political moment changes and what it does not. We are told we are entering phase 2 of the ceasefire stage, a stabilization plan, a reconstruction framework. But many of the discussion shaping these arrangements are still taking place without the meaningful participations of Palestinians or Palestinian women, even though they live with the consequences each day. If ES 1024 is to move from text to practice, we have to ask a simple question. Do the arrangements now being discussed remove the barriers that constrain women, or do they leave barriers intact? Stopping the bombings does not by itself dismantle the systems that restrict women's movement or their access to resources, healthcare, or services. If those systems remain in place, what changes for women beyond the sound of the sky? If civil registry access remains limited, displaced women will still struggle to secure property claims. If monitoring access to detention facilities or monitoring what's happening in those facilities or displacement sites remain restricted, abuse may continue without oversight. That is not stabilization. That is suspension. A civilian governance like LNCAC, any arrangement that cannot enter the territory, Gaza, or move freely or operate independently cannot protect the people living inside it. When formal authority has no real access, people are pushed back into informal systems where actually their safety depends on negotiations, not rights. And the third issue, what we just heard, the legal question. In July 2024, the International Court of Justice issued an advisory opinion outlining the legal consequences of the occupation and the obligations of states not to assist unlawful situations. For lawyers, this is a question of state responsibility. For Palestinian women, it's a question of whether the system shaping daily life will continue without accountability. Law either protects lived reality or it does not. Taken together, the advisory opinion and ES 1024 create a practical test whether the current political initiatives translate obligations into real guarantees for women's movement, protection, and participation. That means gender-responsive safeguards must be built directly into ceasefire monitoring, transitional governance, and reconstruction mechanisms from the start, not added later as an afterthought. So, what does that serious implementation looks like in practice? I have few ideas. First, any stabilization or transitional governance arrangement must guarantee civilian access from the start, not later. That means pre-authorized entry and movement for civilian administrators, safe passage for women civil servants, health workers, and social workers, and real operational space for women-led civil society organizations inside the displacement sites. Without that, governance stays on paper. Second, we need an independent, gender-focused monitoring mechanism linked to ceasefire implementation. This should include access to detention facilities, presence in major displacement hubs, public reporting on compliance, and confidential channels for women and girls to report abuse safely. Monitoring delayed, as you know, becomes monitoring denied. Third, legal identity and housing rights must be protected. Member states can help by funding mobile documentation units staffed by women legal professionals and by tying reconstruction financing to non-discriminatory house allocations and enforceable tenure protections for widows and female-headed household. Fourth, reconstruction must create real economic space for women. That means procurement quotas, gender-responsive contracting, and accessible credit for women rebuilding small businesses. Lastly, fifth, states must examine whether their trade, as already been mentioned by my colleagues, security ties, and material assistance are helping sustain discriminatory systems. Accountability is not retribution. It is about changing incentives so that restrictive systems are not treated as routine. Let me end with this one simple point. A ceasefire that leaves systems of control intact is not peace. It is containment. And containment always looks the same. Restricted access to services, restricted access to justice, mobility, and political voice. If the implementation of ES 1024 does not change the systems that structure women's daily lives, its promise will remain only declaratory, not transformative. Gaza's devastation is extraordinary, but postponing women's rights in the name of political sequencing will only reproduce the same inequalities in the recovery phase. And if we normalize that logic here in this situation, we should not expect it to remain confined to Gaza. Thank you.
Your Excellencies, ladies and gentlemen, dear colleagues and friends, I would now like to open the floor for comments and interventions by committee members and observers. I give the floor to Cuba.
Mr. Chairman, colleagues, good morning. First of all, I would like to thank the Minister of Women Affairs of the State of Palestine for the information provided, as well as the other panelists. Has been indeed a very good and timely convening of this meeting within the framework of the CSW. As the topic we are discussing today makes clear, there is an urgent need to put an end to the discriminatory laws and policies against Palestinian women and girls. Israel continues to violate the ceasefire agreement with impunity. Since it was signed, hundreds of Palestinians have been killed, including women and children. The struggle for gender equality will remain incomplete as long as Palestinian women continue to face the cruelest examples of occupation and genocide every day. The situation in Palestine is a clear instance that underscores how much injustice still exists against women. Since October 2023, more than 12,000 women in the Gaza Strip have lost their lives, thousands of them mothers who were denied the right to see their children growing up. Women and children make up a high percentage of the hundreds of thousands of Palestinians who have been injured and are now suffering from psychological trauma or living with disabilities. Thousands of children and women remain missing under the rubble. These figures reflect the pain of orphan children and the suffering of entire families and households that have been completely torn apart. Israel has obstructed the full enjoyment of human rights by Palestinian women who have been victims of systematic starvation, forced displacement, and violence, and have suffered this effect of health crisis and limited access to essential services. They are stripped of their right to health, education, food, and decent housing, as Mr. Amal Syam has clearly stated before. This is the result of decades of illegal occupation and colonial practices. Those responsible for the crimes committed against the noble Palestinian people must be held accountable. Israel's expansionist claims to seize Palestinian territory will not extinguish the legitimate aspiration of thousands of Palestinian women to exercise their right to self-determination, to live in peace on the land that belongs to them, and to have an independent and sovereign state within the pre-1967 borders, with the East Jerusalem as its capital, which also guarantees the right of return to refugees. Finally, we reiterate our deep admiration and unwavering solidarity with their just cause. Their resistance in the face of barbarism is a beacon of hope of all women around the world, and in particular for the Cuban women. I just want to make a kind proposal to have a voice of Palestinian women in the civil society meeting that we are going to have in Brussels in the coming months. It's going to be very important to have their voice over there. I thank you, Mr. Chair.
I thank the distinguished representative of Cuba. I now give the floor to the distinguished representative of Namibia, to be followed by the League of Arab States, and then Senegal, in that order. Namibia, you have the floor.
Chairperson, we acknowledge the statements and interventions of the Honorable Minister and the distinguished panelists. This year, the UN Commission on the Status of Women reached 70 years since its establishment in its mandate to promote the rights of women. Yet for many women across Gaza and the West Bank, as well as children and persons with disabilities, their lives remain under constant danger and their rights severely curtailed, including their right to adequate food, water, health, medical care, housing, sanitation, education, and basic freedoms. Namibia remains gravely concerned at the continuous bombardments, killings, and the use of rape as a weapon of war. 80 years since the foundation of the United Nations, the promise of the end of the scourge of war is yet to become a reality for millions of Palestinians. Chairperson, about 2 months ago, the world witnessed the demolition by Israel of several buildings inside the UNRWA compound. This comes after the Israeli government stripped UNRWA of its privileges and immunities and seized their headquarters. These were unprecedented attacks against the inviolable UN premises that should enjoy protection by all states as prescribed under international law. And the UN Secretary General had condemned this demolition in the strongest terms. Namibia therefore joins the international community in calling on all parties to ensure an immediate and genuine ceasefire, and for Israel to uphold its obligations and provide unhindered humanitarian access to all affected populations, and to ensure the protection of civilians in accordance with international humanitarian law and international human rights law. All Palestinians, including women and children, must be enabled to build a future free from dependency and despair based on their rights to justice and accountability. I thank you.
Thank you, Namibia. I now give the floor to the distinguished representative of the League of Arab States, to be followed by Senegal and Guyana. Thank you.
Thank you, Mr. Chairman, and thank you for the committee for convening this important side event. And thank you personally for chairing this side event as a representative, permanent representative of Namibia, the country that initiated the 1325 resolution on women, peace, and security, and that have already fought for this cause up till now, including the adoption of several resolutions that have already been in place in the Security Council. And I would like to thank Her Excellency the Minister for the comprehensive statement, and the various speakers, Ms. Syam, Ms. Zaher, Ms. Mazloum, and Ms. Kasbari for their detailed and comprehensive presentations on various aspects related to the implementation of Resolution ES 1024. I think that we, through this event, have already put our fingers on some of the key elements that we should be addressing through our process of how to implement this important resolution. The first aspect I noted was overcoming impunity. I think that what was mentioned about the implementation of the ICC arrest warrants against Netanyahu and Gallant are very important, and other members of this extremist Israeli government. Ensuring reparations, and this year is a year of reparations in the African Union, if I am not mistaken. And as someone who have already served as Under-Secretary General for Africa, I know how important reparations is important to Africa, and reparations are important to Palestine as well. Reparations on all aspects that have been touched upon by the distinguished speaker in this regard. Ms. Mazloum, I think. And we have already some examples that have already materialized through the resolution that we saw in the General Assembly related to Ukraine. And the permission that was given through that resolution to the European Union to confiscate the assets that belongs to the Russian Federation in the European Union countries, and to direct them against reparations for Ukraine. So we have many examples, and there were many examples that were mentioned by the distinguished speaker, and I would like to highly commend her academic and classifying of the issues. So this is a very important issue that the committee could also take into consideration. Returning of the tax money for the Palestinian Authority is going to really give a big push. $5 billion are being withheld illegally by the Israeli authorities. This money, if it came back to the Palestinian Authority, it will be a big push for the implementation of the various initiatives that were mentioned by the distinguished minister here today, and the reforms that to be done on the family laws, on the national committee to counter the violence against women, and to enhance the mechanism on the third generation implementation of 1325, on all aspects, social, economic, and in the preparation of the Palestinian Constitution, which we would like to see much more participation from women in the drafting and in the approval of this of this new constitutions when it comes to action. Also, the implementation of the rehabilitation and reconstruction plan that was adopted by the Arab Summit in Cairo and supported by the New York Declaration is very important. We should not keep this plan hostage to the 20-point plan of President Trump or to the Council of Peace commercial activities that are being done in Gaza. I think that we should move ahead with generating the required resources and the technical aspects for the implementation of the rehabilitation and the reconstruction plan that was approved by the Arab side and with the support of the of the OIC and with the support of the non-aligned, I must say. Also, I highly appreciate the initiative or the proposal by Ms. Kasbari about building gender perspective that safeguard the interests of women while we are negotiating peace agreement. And to achieve this, I think that women should be included in the delegations that are negotiating peace agreements, and we in the Arab League, we support that. Finally, I don't want to take much time. The role of UNRWA. UNRWA is a very important role, and it's becoming even more and more important with the continuation of the Israeli attacks on Gaza and its attempt to illegally annex the West Bank through this latest administrative procedures that are aimed at losing all documentation of ownership for the public and private lands and properties in Palestine. We stand firmly against this, and the Arab League has already adopted several resolutions, including at the ministerial level, against these measures, and we will stand firm along with our sisters and brothers in Palestine against all these kind of also against other atrocities that have been already recognized by the International Court of Justice through 2 advisory opinions, and the advisory opinion also as well that was adopted about the illegality of the actions taken by the Israeli government against UNRWA. Thank you, Mr. Chairman.
I thank the distinguished representative of the League of Arab States. I now give the floor to Senegal.
President.
Chair. Your Excellencies, Mr. Mansour, Excellencies, Ambassadors, distinguished participants. Allow me to thank and congratulate the keynote speakers for their fascinating statements. Today's presentations touched upon the different aspects of the impact of this conflict on Palestinian women and girls. We all know that women and girls are the first victims of armed conflict. And Palestinian women have not escaped this trend. In the occupied Palestinian territories, all fundamental rights are systematically violated by Israel with impunity. Unspeakable suffering is caused, and it should not only be measured by the physical violence that the Israeli army metes out, but they need to be measured based on the practices that lead to the uprooting due to forced displacement, the dispossession of all property, dislocation of families that have been decimated by the loss of close loved ones, insecurity and terror that are permanent, and which mean that every day is a fight for survival, but also the pain of each woman seeing that their children are deprived of protection, health care, education, food, due to the prohibition on the activities of UNRWA, as well as the use of famine as a weapon of war. Ladies and gentlemen, Palestinian women and girls have not committed any crimes. They are the victims of a conflict that has ravaged their past and their present, and that is currently putting in question the future of their children. In the face of so much suffering, the international community must not remain silent. It is our collective duty to ensure that these Palestinian women and girls have a decent life in accordance with international humanitarian law, based on also on the opinions of the International Court of Justice and the decisions of the General Assembly. It is to do this, it's important to initiate in the relevant jurisdictions, whether national or international, to bring perpetrators and accomplices of crimes committed in Palestine to justice and accountability, and to implement the peace agreement and the New York Declaration, which in all the various security, humanitarian, economic, political, and especially legal and judiciary dimensions, so that peace prevails at last in Palestine, and that the inalienable rights of the Palestinian people can be implemented for them to have an independent state and have a peaceful future. Thank you.
I thank the distinguished representative of Senegal. I now give the floor to the distinguished representative of Guyana, to be followed by Nicaragua.
Thank you, Chair. Ambassador Penda, and I also like to greet Ambassador Riyad Mansour and to thank Minister Mona Al-Khalil for her statement, and also our panelists, Ms. Syam, Ms. Zaher, Ms. Fattom, and Ms. Kasbari. I think that this side event is very, very timely, as it reminds us what the devastation that the war in Gaza has brought to women and children there. The figures are staggering when it comes to women and girls. Just listening to more than 33,000 women killed, 23,000 are widows, 9,000 mothers killed. And then there are those things that figures cannot be attached to. How do we put a cost to pain, to the malnutrition that has been brought on women and children? And I think that if we look at the conflicts across the world, all with their different nuances, I think one can say this one is unprecedented just in the level of intensity and the time with which it has happened, and what has happened for women in that. I think this is right up there. And as the media and the world turn its attention to other things right now, I think we have to make sure that the situation in Palestine and for the people of Palestine is not out of our thoughts and not out of when we have to use our voice to call out what is wrong in this world. We have to make sure that we keep this issue alive. And I want to thank the panelists for reminding us of our responsibility as third states, non-recognition, non-assistance, and positive duty to act, because we can do something apart from using our voices as well. And my third point is on the issue of reparations. In many, I would say, theaters in the UN, sometimes when you use the word reparations, it's as if it's a bad word. But I think when we speak of reparations in the Caribbean community, reparations for slavery as a crime against humanity, and when Africa speaks about reparation, that we must also, all of us, remember that reparations for the people of Palestine must be equal as well in this, as they continue to suffer every day. We must not see reparations as a bad word. And finally, I think that while there is a quote-unquote peace agreement, that agreement does not eclipse the atrocities that are still being committed against the people of Palestine in the West Bank, in Gaza. The withholding of revenues to the Palestinian Authority is unconscionable. especially at a time of great need. Access to humanitarian aid is still a major issue. All this means that justice for Palestine, justice for Palestinian women and girls continue to remain out of reach. And as we speak about access to justice in this CSW, we must continue to put this at the top of our agenda for the Palestinian people, because unless women and girls and the people of Palestine receive justice, there will be no complete justice in this world, and it will continue to remain out of reach. I do not have any questions. I just wanted to say these few words.
I thank the distinguished representative of Guyana. I now give the floor to the distinguished representative of Nicaragua.
Thank you, Mr. Chair. We thank the committee for convening this important event. Our appreciation also to Her Excellency Muna Al-Khalil, Minister of Women Affairs of the State of Palestine, and the panelists for their presentations. We express our firm solidarity with the people and government of the State of Palestine facing systematic human rights violations committed by Israel, which are exacerbating the suffering of the heroic Palestinian people. The situation of Palestinian women and girls, as described, is particularly alarming. They are the primary victims of a web of discriminatory laws and policies that include home demolitions, settler violence, and forced displacement. These practices, which constitute forms of collective punishment, have a disproportionate impact on their physical and psychological well-being, limiting their access to basic services and a life of dignity. These actions not only destroy families, but also seek to break the legitimate resistance of the Palestinian people. Access to justice for Palestinian women and girls is inseparable from the end of illegal occupation. It is imperative that effective measures be implemented as stipulated by General Assembly resolutions and the advisory opinions of the International Court of Justice to ensure Israel's accountability for the crimes documented in Gaza, the West Bank, East Jerusalem, and all the occupied Palestinian territories, to end Israeli apartheid, and to guarantee the protection of the Palestinian people. We salute, as always, the resistance of the Palestinian people, the resistance of the Palestinian women, pillars of their community, and reaffirm our support for the cause of the State of Palestine in exercising its inalienable rights of self-determination, sovereignty, the right of return, the right to live and develop in peace, and to an independent state within the 1967 borders with East Jerusalem as its capital. I thank you.
I thank the distinguished representative of Nicaragua. I now give the floor to the distinguished representative of Egypt.
Thank you so much, Mr. Chair, Excellencies, distinguished delegates. We extend our appreciation to the Committee on the exercise of the inalienable rights of the Palestinian people for convening this important event on the margins of the 70th session of the CSW. This discussion comes at a critical moment as Palestinian women and girls continue to endure the severe and disproportionate impacts of the ongoing Israeli occupation, including the persistence of discriminatory laws, policies, and practices that undermine their fundamental rights. Egypt remains deeply concerned by the systematic challenges faced by Palestinian women and girls, including restrictions on freedom of movement, limited access to essential services such as healthcare, education, and justice, as well as exposure to various forms of violence and socioeconomic hardships. These conditions are further exacerbated by the broader humanitarian situation in the occupied Palestinian territory. Excellencies, discriminatory policies and practices under occupation not only violate international humanitarian law and international human rights law, but also hinder efforts to achieve sustainable development, gender equality, and the full realization of the rights of women and girls. In this regard, Egypt reaffirms the necessity of ensuring accountability and upholding the rule of law, The international community must intensify its efforts to address these violations, ensure protection for Palestinian civilians, and support the resilience and empowerment of Palestinian women and girls. Excellencies, achieving justice for Palestinian women and girls requires not only addressing immediate humanitarian needs, but also tackling the root causes of their suffering, foremost among them, the continuation of the occupation. We further underscore the importance of preserving the centrality of the Palestinian cause and reiterate our unwavering support for the legitimate rights of the Palestinian people, including the right to self-determination and the establishment of their independent state on the 4th of July 1967, lines with East Jerusalem as its capital. I thank you.
I thank the distinguished representative of Egypt. If there are no more requests for statements from member states, we will open the floor for questions and comments. And I see we have one of our colleagues who wish to take the floor. I think it's one of the members of our NGOs or civil society. You have the floor, sir.
Thank you, Chair. I'm David Wildman with the Global Ministries of the United Methodist Church, and I'm also one of the co-chairs of the NGO working group here in New York on the question of Palestine. And so I want to just thank the committee for this and also thank all of our panelists. I think it shows the strong years of dedication of civil society and especially Palestinian women for the work for justice and Palestinian rights that the UN has been struggling for since almost since its inception. So I did have 3 questions, one for each of our speakers who I think are still on the line, I hope, and here in the room. So for Sawsan Zaher, with the cases and how you raised the questions around the Israeli injustice system that blocks Palestinians from due process and remedy, I'm wondering, are there roles or measures that third states could take in relation to these cases when Palestinians have been blocked by the Israeli courts? And would love to hear your thoughts on that. For Lina, Fattom, thank you for that very clear description of reparations and the needs. I'm wondering if you could share suggestions of enforcement actions, especially for Palestinian refugees that have been seeking and needing reparations since 1948. And any thoughts on steps, again, that third states could join in with. And for Carol, Daniel-Kasbari, thank you for your explications of the current situation and that it's too urgent to wait. I'd like to ask specifically on the question of monitoring and compliance. We've had ES 1024 since last September, and it has not been fully complied with and implemented. So I'm wondering what compliance reporting mechanisms could be used now. When you said monitoring delayed is monitoring denied. And so if we apply that to ES 1024 and some of its calls for trade sanctions and arms embargoes by all states, I'm wondering if you could share a little bit of some steps of what that might take to begin to move towards greater compliance with ES 1024 and the ICJ advisory opinion. Thank you very much.
Thank you, sir, for your comment and questions. Are there any other questions from the floor or comments? I see none. Before I turn to the panelists to respond, I have additional questions for Dr. Daniel-Kasbari. And these are 2 questions that came in, and they are as follows. Question number 1, based on your remarks, how have movement restrictions, documentation, barriers, and displacement affected the daily lives of the security of Palestinian women and girls since the war in Gaza began? Question number 2, you mentioned the importance of incorporating gender considerations into the implementation of General Assembly Resolution ES-10/24. What concrete steps would member states take to ensure that women's rights are protected in the current ceasefire and reconstruction discussions of Gaza. Could we perhaps start with Ms. Zaher? Ms. Zaher, are you on the line?
Yes, I am.
Thank you.
I'm
you
back.
have the floor.
Can you hear me?
Yes, indeed, we can hear you.
Yeah. Yes. It's a very important question about the responsibility of third state parties, and of course there are variety of issues that can be decided and adopted and conducted as well by third state parties, especially with obligations that arise from international legal instruments. But of course, there are political decisions that can be taken to pressure Israel to, first of all, to stop the genocide because it is still happening, but also to provide justice not only for women and children, but for all innocent Gazans that have been basically affected from the genocide in all fields of their lives. In addition to that, there is also of course, the economic level, with the reparation level that my colleague as well had already mentioned. But I would like to focus on the legal obligation or legal aspects of third state responsibility in this regard, because when justice is denied in an aggressive way in the Israeli legal system by the perpetrator itself, then the only option is basically on the international level, whether as a collective, which is the UN and other international or regional bodies, and on individual level in individual states. And I started at the end of my presentation talking about what can be done, of course, with the already issued decisions by the ICC. For example, the arrest warrant issued against Netanyahu and Gallant, and how states on individual level are basically responding on the fact of having a motive to respect and operate to implement the arrest warrants when these officials would arrive to their country and to their territory. Based on international law, there is an obligation to respect such decisions. But it's not only the arrest warrant, because as we all know, and it also arises from my own presentation, that we're not talking about a one-man decision or a two-man decision. We are talking about a whole system that is being backed up by politicians, by the legal system, by the public opinion as well, not to stop even the genocide and continue with it, and not to provide any effective remedy to Gazans. And in this respect, we already have at least two major orders that were issued by the ICJ in the proceedings that were initiated and submitted by South Africa against Israel in the genocide case, where it illustrated the obligation of third states in preventing, not only stopping, but also preventing the continuation of the genocide. Now, of course, I think that unfortunately, not all states have adopted measures in alliance with the ICJ orders that were issued in January 2024 and later in March and May 2024. And instead of issuing statements that provide steps to implement the orders and the ICC decisions, we basically saw that there were other statements. If we take a look at, for example, at the statements of third states to recognize the state of Palestine, at the time that, which was, as you all remember, almost a small while before the ceasefire was declared. That was in September. It was at the same time that the UN took a resolution to implement the ICJ decision issued in July 2024, which was a year before, to basically implement the decision about the illegality of the occupation and the evacuation of the Jewish illegal settlements in the West Bank. And the deadline passed. The resolution was not implemented. We only saw declarations of recognizing the state of Palestine, but there was no statement and no actual step towards implementing other more legal decisions. And I'm sorry for being blunt or critical in my answer, but I think it's like the not doing things on the ground to stop the genocide and help provide effective remedy for the victims and the survivors, especially when we are talking about women and girls, where a whole generation has been wiped out, and with the fear with what is going to happen with the rest, because as we all know, the genocide is not over. And therefore, I would want to take this opportunity to stress again the legal obligations that arise from international law on third states party in the regards that I have been mentioning. Thank you.
Thank you, Ms. Zaher. I would now like to give the floor to Ms. Fattom to give a response, and kindly request, due to time, to be as short as possible, and also to include her concluding remarks in that. Ms. Fattom, you have the floor.
Thank you, Excellency. I think I appreciate very much your question, Mr. Wildman. I think it is a very complicated answer to give to you in some senses, because the right of Palestinian refugees to return and the reparations that come with that are part and parcel and tied very closely to some of the violations that we see, including the continued apartheid system across historic Palestine, and as well as the denial of self-determination. I don't think that there is one quick answer for what can we do to actually get enforcement. However, I believe that there are a number of different actions that can be taking place. As we've seen in the past couple of years, there has been a systematic effort, and it's actually been much longer, right? So it started over decades ago. However, in the past 2 years, Israel has very clearly targeted any kind of recognition of Palestinian refugee rights, including through the targeting of UNRWA as a UN mechanism to support Palestine refugees. I think one of the things that can be done by third states is reinforcing the rights of Palestine refugees to both the right of return and restitution to their home place, no matter where that may be, as well as compensation that they're entitled to. In addition, I would say that reinforcing and supporting the right of UNRWA to continue to operate, and indeed punishing, as the UN is supposed to do, for a member that refuses to recognize the immunities that are accorded to an agency like UNRWA, by enforcing certain kinds of sanctions, whether they are within the UN or even external to the UN, is part of the answer to ensuring that the rights of refugees remain strong and within the system of discussion. In addition, I would say that I would even expand the mandate of UNRWA in this period to include this is something that has always been a discussion to include the protection of Palestine refugees where they may be. And as we talk about, here we've talked a little bit about the occupied Palestinian territory, which includes between 2.5 and 3 million Palestine refugees. But UNRWA also operates in Lebanon, that is now being very clearly targeted by the Israeli assaults there, and as well as in Syria, where the political upheaval has not allowed for the provision and support of Palestine refugees as well. I think that the situation on the ground allows for multiple ways in which third states can act to reinforce those rights of Palestine refugees, to preserve their ability to challenge systems, and for many of those refugees that are in the third states that actually now have citizenship or ability or residency in those third states, if those third states would allow those citizens to challenge those violators, including the Israeli actors themselves within their court systems, it would allow for a way in which to reinforce again the political and legal rights of Palestinians under the international legal system. And that is something that I think all states have not only an obligation, but also a kind of need to do so in order to preserve their own rights in that legal system. And that's something that many forget. As we've seen this in the Ukraine situation with Russia. I think that there is nothing that prevents actors, including states within the UN system or external to that, to actually take similar actions against the state of Israel that is acting with absolute impunity and undermining the entire legal order.
I thank you, Ms.
Thank you.
Fattom.
And yes.
Please proceed. I thank you, Ms. Fattom, for your response. I now give the floor to Dr. Daniel-Kasbari. Dr. Kasbari.
Yes, thank you. So I'll try to reply to all three questions quickly. Thank you, David, for raising this very important question about compliance and monitoring. I would make one basic point about that monitoring only matters if it's tied to protection, accountability, and consequences. Otherwise, it becomes a record of deterioration. Oh, the situation has deteriorated, this and that, rather than a mechanism for changing behavior. So if ES 1024 is to move from text to practice, then implementation has to be assessed through the lived realities of these women, whether women or civilians in general can move safely, whether they can access their papers, any access is restored, whether their documentation can be recovered, whether detention facilities are monitored, and displacement sites are also open to independent oversight, and whether women and girls have safe and confidential channels to report abuse. That is the gendered protection lens I was trying to bring into the discussion. So for me, compliance is not only about whether the shooting pauses, it's about whether the systems that are shaping the daily lives are actually changing, right? So access to food, access to services, and meaningful participation. So the General Assembly resolution already created actually a reporting basis through the Secretary General. But as you all know, reporting is not alone and is not enough because it's also asking for reporting every 6 months, not every day, not every week. So it also needs independent verification, right, by independent people. And it needs public reporting. Like any ceasefire and any situation, you need observers to do that in a very independent and public way. And also it needs a structural review of non-compliance. structured review of non-compliance if it is to carry real weights. So the same applies for the ceasefire monitoring. A ceasefire mechanism cannot be conceived only as a military or technical arrangement. It also needs a civilian protection function, something I have spoken about many times and also in my writings. That means access to places where abuse is most likely to occur, direct channels to civilian reporting, including women-led organizations such as the Gaza Center of Women, and also some form of follow-up when violations are identified. They cannot really be ignored. So I would put it this way: a credible monitoring mechanism for both ES 1024 and any ceasefire should have 5 elements. 1, independent verification. 2, access on the ground. 3, public reporting. 4, safe protection channels for civilians, and especially women and girls. And 5, agreed consequences or follow-up when violations occurred. Otherwise, as you all know, monitoring risks becoming observation without protection, and compliance becomes a rhetoric category, nothing more. In terms of your question, Chair, about how the current systems are affecting the daily lives of women and girls in Gaza. And, you know, this question is about Gaza, but I have to say it's also about the West Bank and East Jerusalem. So first, what we are seeing right now is that these barriers affect women and girls at several levels at once. First, they have increased the daily burden on women. Women are often the ones who are trying to bring the family together. They're the ones who try to replace missing documents, register children, secure food assistance, arrange medical care. I'm not talking here that men are not doing that, so not to misunderstand, but since this is really about women and girls, especially in this situation, I have to say that the systems are not so designed around the realities they are facing. So the burden falls on them most of the time in a disproportionate way. So second, how they're affected, they have weakened women's ability to claim rights. When their identity papers, their property deeds, their marriage certificates are lost, it becomes much harder to prove claims to inheritance, to housing, to custody, to services. So for widows, you can imagine, and female-headed households in particular, that can create prolonged legal and economic uncertainty. And for girls, repeated displacement and administrative breakdown can interrupt schooling, increase dependency, and as you all know, heighten the risk of exploitation and early marriage and exclusion from education and public life. So more broadly, these barriers are, also affect security because when institutions stop functioning, people are pushed to rely, unfortunately, on informal systems and local power to access resources or resolve local disputes. That may help in the short term, but it often places women and girls at a very disadvantaged point. So, as you hear, the impact is not only humanitarian, it is also institutional and political, because these systems shape who can move, who can claim rights, and who can access protection. In terms of your last question, the third question about incorporating gender into the implementation of the General Assembly Resolution ES 1024 and what concrete steps the member state can take to ensure that women's rights are protected in the current situation and also in the reconstruction discussions in Gaza. One point I would make is that the implementation of this resolution is not only about adopting new policies. It is really about how the political and administrative arrangements now being discussed for Gaza are designed from the outset. As my colleagues say from the Arab League, he also mentioned that. Right now, discussions around stabilization, arrangements, and transitional administrative structures and reconstructions framework will shape the institutions that govern recovery. So if gender is integrated early, it can influence how these institutions function for years to come. If it's postponed, then inequality is risked becoming built into the system from the beginning. So I think I mentioned in my remarks earlier some practical steps, but I think I will make them more practical now. So first, member states can ensure that women are not represented in emerging, not only represented in emerging governance and reconstruction bodies, but that those bodies have the mandate, resources, and operational access to address issues that affect women in a disproportionate way, including housing, recovery of documentation, access to health care, and protection for displaced families. Second, they can make reconstruction financing conditional on inclusive access and accountability. That means supporting transparent monitoring mechanism, protecting legal identity and housing rights, and economic recovery programs that are accessible for women from the very start. Third, they can use technical assistance and diplomatic engagement to ensure that gender is treated as part of the institutional design of recovery, not as a secondary issue to be addressed later. So in many post-conflicts, and I have to say, this is not a post-conflict, but I mention it as to say in many post-conflict settings, delaying gender considerations, as we saw in many countries, locks inequalities into property systems or service delivery, livelihood programs, in ways that becomes much, much, much harder to reverse. So if women are absent when institutions are designed, those institutions will for sure reflect that absence. So implementing 1024 ultimately means making sure that the recovery structures being built today allow women not only to access services and institutions, but also to shape them in ways that matters to them. Thank you.
Let me thank all the panelists for their comprehensive responses. I now give the floor to His Excellency Minister Riyad Mansour, Permanent Observer of the State of Palestine to the United Nations, for his concluding remarks. Your Excellency.
Thank you very much, Ambassador. Allow me at the beginning, to express our gratitude to the committee, to the Bureau of the committee for organizing this very important event, side event, on issues related to the legal aspects affecting Palestinian women and girls, especially in the occupied Palestinian territory. And also through you to thank the Division of Palestinian Rights in the Secretariat of the UN, who made this event a very possible event. I want also to thank the panelists, all of them, so enlightening to listen to them. From Gaza, Amal Syam, from inside the green light of Summer Zaher, and to the fabulous lawyer in Ramallah, Lina, Fattom, and of course to this globally outstanding scholar and active individual, Dr. Daniel-Kasbari, for being with us and to share with us a tremendous amount of information that is extremely useful for those who want to dwell at depth in all of these issues and details. Of course, I want to thank all the others who are with us, especially those from the civil society organizations and the many people who are watching us through the web of the United Nations. We are grateful for all these things. And also, I just want to say that we, the Palestinian people, have come a long way in our continuous struggle for the attainment of our rights, including our right to self-determination, statehood, and the right of the refugees to return. And we endured so many pain, including genocide. While we are struggling for acquiring our rights, we are not giving up. We are continuing the course, and we are being creative through this march in tapping every possible way, including going to the ICJ often, including contributing in a significant way for the historic advisory opinion of the ICJ that has tremendous amount of reaffirmation on the basis of the law of the rights of the Palestinian people and what Israel is not allowed to do as being illegal, including this illegal occupation that has to be terminated. And also before that, we entered the UN, the General Assembly, the Security Council, the Human Rights Council, in every aspect on the basis of the rich struggle of our Palestinian people and sacrifices, and we were able to succeed in framing what our rights are and succeeding in having support of the international community to these rights and the minute details of these rights through the resolutions that being reaffirmed, every year in these different components of the international community at the United Nations. But for the last 2 years, we made a determination when we decided to go to the ICJ for an advisory opinion that meaning to take the entire Palestine question to be dealt with from a legal aspect. We decided now this is not enough from all of our colleagues and brothers and sisters and the countries that support us and the 160 countries that have recognized the state of Palestine. Now, for the last 2 years or so, we are entering the stage of implementation. It is nice to tell me that you reaffirm the rights of the Palestinian people to self-determination, but it is nicer to add to it practical steps to get us closer to that objective. Now, practical steps not only in the United Nations, not only in the ICJ, not only in the ICC, but third state parties, you can do so many things in your national capacity. You can drag as many as you want of those criminals who are committing all these evil things against the Palestinian people in your national legal systems. We learned from the experience of South Africa and Namibia that the international community and third-party states can do a lot in order to make this illegal occupation have to encounter heavy price for it, to the point that breaking the backbone of this illegal occupation and for our people to have freedom and dignity in our own state through the exercise of self-determination. That stage is more difficult than the 20 years of struggle or so before it in reaffirming our rights. Because now to move from reaffirming our rights into implementing our rights and to make it a reality, it requires from state maybe a bigger decision to make, and many of them, they do calculations. We need to figure out the puzzle of how we can convince them in order to move in that direction. Maybe these talks appear more difficult under the prevailing conditions, but I trust the genius of the Palestinian people in steadfasting and being creative and adapting and adjusting to the new realities. Together, as we heard today, it's just only a sample of what what we could do and a sample of the basis in which we can rely on. But also you've seen samples of the resiliency of the Palestinian people. When my sister Amal Syam from the middle of Gaza gave you statistics and asked you for certain things, this is remarkable, from under the rubble. When you see, my sister Zaher in the most difficult, vicious legal system against the Palestinian people in Israel, still they are tapping the Supreme Court of Israel and they're not giving up, although maybe, as she said, that there was a case that they won more or less among hundreds, maybe thousands of cases. This is, learn from us, the Palestinians. We don't give up, we're resilient, we're creative, we'll stay the course. We want to see more of you getting closer to that kind of culture so that we can get closer to, to get closer to the accomplishing the objectives of what we want. And let me conclude by thanking my sister, the Minister of Women's Affairs of Palestine, for being with us. It is shameful that she and maybe the experts that were with us, some of them, and many others who usually used to be with us. We used to have a minimum of a delegation of 20 Palestinian women leaders, whether from the governmental side, led by the Minister of Women's Affairs, or from the civil society organizations, to have the right to be in the CSW conference, and they were denied the right for simply fighting in a civilized way, in a legal way, in a peaceful way for the rights of the Palestinian people. And in spite of all these qualifications, they denied them visas to come and to participate and to meet with you in person. But nevertheless, we are creative, we use technology. They were with us. Those of them who participated in the panels, including the ministers, but we need your help also to remove this obstacle from our path of our delegations and our leaders and all Palestinians who carry Palestinian passports to have the right to have visas to come, especially those who come to the UN to participate in UN conferences. Again, thank you so much for all you have to do, but we are asking you, we need you to do more because our situation is more difficult. Thank you very much.
Thank you, Excellency Minister Mansour, for your concluding remarks. Let me again take this opportunity to thank the panelists for sharing their insights and information informing this discussion on this crucial topic of access to justice and accountability under occupation. Although we regret most of you were not able to travel, as just indicated by Minister Mansour, from Palestine and Israel to be with us in person today, we are honored to have had you participate in this year's Commission on the Status of Women side event. Your interventions have highlighted once again the importance of women's perspective for the achievement of a just and peaceful solution to the question of Palestine. Finally, let me take this opportunity to thank the interpreters in the conference services for making sure that this meeting takes place as scheduled and in an orderly manner. I'm sure without you, we would not understand each other in the different languages we communicate. We truly appreciate you for this. I thank you, and the meeting stands adjourned.